All right, ladies and gentlemen, I have 9 o'clock. I'm going to go ahead and call the docket. I'll ask for announcements from the attorneys. Anyone who's present who either doesn't have an attorney or you're answer, please make sure that I know that you're here. Starting with the Frio County docket in the interest of the Zamzow children.
Judge, we're present on that. This is Porter Corrigan. Lucinda Vickers is the opposing counsel. We're working on an agreement. We hope to have an agreed order to you here shortly. So if you could just leave us in conferring right now.
Okay, I'll mark you conferring, and I'm going to make Ms. Riley the host. So if you need a breakout room, you may get in touch with her. Okay,
sounds great. Thanks, Judge.
Your Honor, Katie and I are also here in that case, and we're.
Oh, I see. Yeah.
Agree with everything Porter's saying.
All right.
Yes, Vickers just got on to on that case, Judge.
Okay. All right. Just announced confirm, Ms. Vickers.
On Zamzo, yes, we're announcing conferring, Your Honor.
JW Power versus Frio County Appraisal.
Your Honor, Katie Hart on behalf of non-party CTMI, we're the movant on this hearing.
Your Honor, Kurt Swinney on behalf of defendant Frio County Appraisal District.
My name is Emily Steele. I'm attorney for plaintiff JW Power Company.
All right, how long to hear this?
I'm guessing about an hour, Your Honor.
Everyone in agreement?
If not less, but sure.
Okay. Okay, I will mark you conferring. And would it do any good to confer in the breakout room?
I think it would, I would appreciate that opportunity, Your Honor.
All right, I'll ask you to get with Ms. Riley on a breakout room. All right, Karnes County, in the interest of EMC, a child.
Andres Rios on behalf of Abundo Castaneda, Your Honor, about an hour.
All right, who's here on the other side?
Ariel Cordaway.
All right, Ms. Cordaway? I'm asking you to unmute, ma'am. All right, Ms. Cordaway, are you ready to proceed on this case? All right, can you hear me, ma'am? Okay, I can't hear you. It says your microphone is on. Can you say something else?
Can you hear me?
Now I can hear you. Okay, are you at the courthouse?
No.
Okay. All right. Are you ready to proceed, ma'am?
Yes.
All right. I'm going to ask Ms. Riley to open up a breakout room for you and Mr. Cedillos. If you can come to an agreement, good. If you cannot come to an agreement, I'm going to ask you to at least narrow down whatever your issues are, and whenever you come back, we can have a hearing if we need one on temporary orders.
Okay, thank you, Your Honor.
All right, Wilson County, Rockstar Remodeling and Diamond Decks versus Valdez.
Good morning, Your Honor. Joel Rodriguez here. I'm the movant on a motion to withdraw, Your Honor, and I gave clients proper service through email and opposing counsel. I can have an order for you email later this afternoon, Your Honor. I don't believe there's any opposition.
This is Charlie Silfoni for Rockstar. No opposition. I'm just requesting that the order reflect an order establishing how I can contact his former client.
Okay. Mr. Rodriguez?
That's fine, Your Honor. I will include that information on the order.
Okay. All right. I will sign that when it gets to me. If you get it prepared while I'm still in court, you may post it to me in chat.
Okay, will do, Your Honor.
Other than that, you're excused.
Thank you.
Bow wallflowers right now.
I just put Porter Corrigan, Katie Grady Roberts, Marjorie Beckman, and Daniel Corley in breakout room 1.
I know that this freeze, when you go across the countryside, you can see how it knocked everything down.
Okay, and once people have had an opportunity to confer, please come back and report to me what we need to do as far as hearings. I'm going to work on the stuff in my inbox. Please, I'll leave my microphone or speakers running. Please let me know when we're ready to do something.
If anybody else needs a breakout room, please let me know.
They have an agreed bond reduction on, and they're 1 year in office. Get a signature on it. Yeah.
But when I get into a thing, I don't really look at it.
Katie Roberts, Mr. Okay, you went in there.
Judge Wilson, this is Kirk Swinney, Emily Seal, and Katie Hart. We're through with our conference, ready to proceed anytime you are.
All right. Okay, who else is going to be speaking?
Katie Hart on behalf of the movement.
Plaintiff, JW Power, Emily Seal.
And Your Honor, Kirk Swinney on behalf of the defendant.
And is this just going to be argument? No witnesses?
The defendant has no witnesses, Your Honor.
Neither does the movement.
Or do I?
Okay, all right, go ahead, Ms. Hart.
Your
And
Honor,
just let you know, I read the objections and responses to the subpoena deuces tecum. I have not read a response to those objections if there's been one filed.
okay. I just want to reiterate that, again, my client is not a party to this matter. They are a tax consulting firm. Recently, the defendant served several requests for categories of documents covering more than an 8-year period of time. And it is both plaintiff's position and my client's position that much of the requested information is protected because my client was acting as plaintiff's consulting expert in anticipation of litigation it was involved in from 2013 to 2020, the end of 2020. Regarding much of the other requested discovery, our position is it's unduly burdensome because, number one, several of the requests are duplicative of requests that defendant has already served on plaintiff. It's my understanding that documents that have not been produced are, the parties are in anticipation of producing them once they enter a confidentiality order. That leads into my other argument that the documents are obtainable from another source, the plaintiff in this matter. Basically, our position is that the defendant is just going on a fishing expedition into my client's files, and we would just request that the court enter a protective order forbidding the production of these documents. Your Honor, would you like me to go request by request, like I speak and then defendant speak, or would you like me to go through all the requests and then defendant go through all of them?
Well, let's do them one at a time.
Okay. Number one, they request the engagement agreements between my client and plaintiff concerning the subject property. It's my understanding plaintiff has already produced those in another matter, and they have already agreed to produce them in this matter subject to a confidentiality order. Therefore, they're duplicative and unduly burdensome on my client.
And Ms. Seal?
Yes, Your Honor, and that was essentially what I wanted to tell Your Honor today is there is no motion to compel against my client before the court, but in reading the defendant's response, there were notes that plaintiff had refused to produce certain documents, although we initially did assert objections to those and have fought those in other matters in order to avoid unnecessary time and expense, Your Honor's time as well, since we know they will pursue those with additional hearings. We have advised that we're willing to produce the same engagement agreements and communications that have been produced in other matters subject to the same type of confidentiality agreement being entered, and I have sent that over to opposing counsel so that at least covers some of those items. But just to be clear on our position, generally, we are not opposed to defendant discovering documents and testimony that relates to the underlying facts. Our issue is with items that are subject to privilege. And so I think that it's clear in reading their request, there's a great deal that falls outside of just underlying facts.
Mr. Swinney?
Your Honor, I'd like to explain the situation. Not all of my responses will be nearly this long, but if you would indulge me to explain what's going on here, I would appreciate it.
Go ahead.
This is a case by J.W. Power against my client, and it has multiple sister cases across the state. And so if we start referring to multiple other counties, I apologize, we're litigating literally from border to border of Texas and a lot of places in between. Some years ago, there was some litigation between multiple appraisal districts and multiple compressor litigation over the constitutionality of a statute that changed the nature of the taxation of these compressors. Many cases were resolved in favor of the property owner. What happened to bring about this case is after all that litigation was over, J.W. Power came back and said, you know, all those years that we didn't sue you on, we want those too. And they used a vehicle, and it's called section 25.25C of the tax code, which under some very limited circumstances allows people to go back 5 years. 2 of those circumstances of which J.W. Power has availed itself is that they allege that the property didn't exist on the appraisal roll in the form and location described on the appraisal roll, and that it was appraised somewhere else. The vast part of what we're talking about here today is that allegation was it appraised somewhere else? And CTMI is J.W. Power's tax consultant. Well, I'm referring to them as CTMI. They're now known as Invoke, Your Honor. But during much of the relevant times, the documents say CTMI. And so I indulge when I say CTMI, Invoke, it's all the same thing. CTMI was J.W. Power's tax consultant. It is CTMI that filed the documents in other counties that allegedly created this multiple appraisal. It is CTMI that paid the taxes allegedly paid the taxes in other counties, which is the basis of this alleged multiple appraisal. It is CTMI that kept the records. It is CTMI that informed J.W. Power's affidavit, and it is a CTMI employee that swore out an affidavit, which we'll show is a false affidavit in another county, but also in this county, CTMI was the source of information for a false affidavit by J.W. Power. Now, so here's the question for the court primarily is, were these compressors appraised in another county? May I show, this is the affidavit.
Anyone who has the floor, if you need to share screens, go ahead.
Of course, the speed of the computer is inversely proportionate to the need of the information. Your Honor, what we're looking at here is the section 2525 motion that instigated this action. This is before the Appraisal Review Board, Frio. This is the affidavit that was submitted there, and in which J.W. Power alleges, among other things, that for each tax year it issued, J.W. Power self-reported its compressors dealer inventory pursuant to section 23.1241 of the tax code by filing the required declarations in the yard counties, and 2, J.W. Power timely tendered the payment for the inventory taxes on the compressors pursuant to 23.1242 of the tax code. In this case, Your Honor, the yard county is Jim Wells. Are these matters true? As the litigation progresses, so they are not. But be that as it may, this is what was filed. As it turns out, Mr. Tubbs, the affiant here, is entirely relying on CTMI for his information. In fact, as we'll indicate later at the deposition of Mr. Tubbs, in this case, he referred to CTMI 25 times, saying it was the source of information. In another case that was scheduled yesterday until it settled, he referred to CTMI 44 times, saying CTMI did this, CTMI did that, etc. They allege in this affidavit that they complied with section 23.1241 of the tax code and paid these taxes in another county. What that code requires is to report your leases each and every month and pay a portion of the tax each and every month. What we have learned through discovery actually happened is that CTMI only reported the very first month of each lease. As such, they ended up underreporting to Jim Wells County to the extent of approximately 99%. And that the vast majority of the compressors on the Frio County roll were never reported to Jim Wells County, or if they were reported 1 month in 1 year only. And so this paragraph is patently false, Your Honor. In another county, and this specifically Shelby, in a motion for summary judgment, that motion for summary judgment was supported by an affidavit from a CTMI employee who swore, among other things, all the inventory was assigned to Panola County. For each year, JW Power timely filed dealer heavy equipment inventory declarations in Panola County. Those declarations and statements included the Shelby compressors. JW Power tendered payment on the inventory. The compressor schedule shows that each of these units were in Panola County and so on. It goes on through it. We paid Panola County. As it turns out, virtually none of that's true. And this is a CTMI employee at the time, he's no longer, who supported that, that affidavit. At the very least, Your Honor, what JW Power has done through these statements is make some very seriously misleading statements to the court, if not just patently false. In deposition, Mr. Tubbs, who signed the affidavit, stated that at the time he signed the affidavit, which the original one was signed in December of 18, he believed the statements to be true, but that he relied entirely on CTMI for his information. Well, that gives rise to some legitimate discovery. Was it reasonable? Did Mr. Tubbs believe that to be true, or should he have believed it to be true in December of 18? In other affidavits, he signed as late as December of 19, some even into 2020 in other counties. And he's relying entirely on his tax consultant, CTMI, for his information. If Mr. Tubbs does not have reliable information from CTMI, the whole affidavit that supports their case is subject to impeachment, and not only just impeachment, but disallowing, because it's not based on personal knowledge. We've been through multiple discovery disputes, Your Honor. In the initial discovery, JW Power resisted it. There have been motions to compel in 10 counties, including Frio County. The nine counties have ordered it, and the 10th was never set. And then as the discovery came, it became clear that they did not, CTMI did everything. CTMI was the fount of all knowledge. We've inquired, well, when did CTMI tell you that you were grossly underreporting such that your affidavits were known to be wrong? That is a large part of what's in discovery dispute here. Some of the discovery that we have obtained, in which Ms. Seal has indicated will be produced in this case, indicate that clearly prior to December of 18, this was known. This is an April 5, 2018 exchange between CTMI and JW Power, CTMI employee to a JW Power employee, several other people on the CC line. I just wanted to advise on the increase for each county. I've discussed with several folks and don't think there's a good way to ease into this increase. Some have even advised it could be construed as fraud if we don't remit what we believe is due to the best of our knowledge. This is what they're talking about, is moving from reporting only in the first month of a lease to reporting every month of a lease. That email exchange clearly indicates that sometime prior to December of 2018, JW Power fully knew that it was not reporting pursuant to 23.1241 of the tax code in Jim Wells County, and yet is so represented to the ARB and to the court in many cases. They haven't filed a motion for summary judgment in this county, but be that as it may, that's what has gone on in multiple places. Now, again, CTMI is JW Power's consultant to handle all these tax matters from. There is no evidence whatsoever that CTMI was a purely consulting expert or that it was an alter ego of JW Power. We'll get to that in just a moment, such that it could claim a privilege of communicating with JW Power's attorneys. In fact, JW Power and through their attorneys have disclaimed having any control over CTMI. In the Shelby County case, when Shelby CAD asked for depositions of CTMI and Mr. Luna, it was represented by JW Power. This is JW Power's attorneys that, well, here's our Ms. Gaines. Mr. Luna is an employee of CTMI, or this is Mr. JW Power's lawyer, not JW Power. We do not control him. He is not our employee. Noticing us for his deposition, I don't think is a proper way if they want to try and issue a subpoena. Frankly, I don't know if that will work. He might not. He might be more than 150 miles. And this is Shelby's counsel. And counsel, correct me if I'm wrong. I'm sorry, it's the court. But CTMI is a tax agent for plaintiff, correct, Mr. Nansen? Yes, the tax filing issues, Ms. Gaines. So, Mr. Nansen, again, that's JW Power's attorney, not a general agent for JW Power. And so what has happened here is, in this case, Frio CAD is seeking discovery on this source that actually did most of this relevant information. And say, okay, when did you do what? Did you in fact report in Jim Wells County? When did you know you weren't properly reporting in Jim Wells County? When did you inform JW Power that you were not properly reporting in Jim Wells County? At the depot of Mr. Tubbs, JW Power's designation, Mr. Tubbs testified, CTMI filed all pertinent renditions. CTMI filed all monthly dealer heavy equipment inventory tax statements. CTMI filed all annual declarations for dealer heavy equipment tax. CTMI paid all the taxes, and I mean, it billed JW Power for it. CTMI kept all the records. CTMI supplied the records to JW Power. CTMI made the decision to file only in the first month of a lease. CTMI alerted JW Power that the filings had been erroneous. And not in the Frio deposition, but in another deposition, Mr. Tubbs identified Mr. Luna as his primary contact at CTMI. CTMI filed all the protests for JW Power during 2013 through 16, which were simply not followed up with suits. CTMI employee Mr. Luna filed the false affidavit in Shelby County. Again, 25 times in this deposition, 44 times in the Clay deposition, Mr. Tubbs referred to CTMI as the source of his knowledge. The only expert witnesses identified in this case, Your Honor, have been attorney fee experts. What a purely consulting expert would advise on is unknown. Mr. Luna has already been deposed, and when asked, "Are you an expert on anything? Have you been asked for an opinion?" He said, "No, I don't consider myself an expert on anything." Like I say, what CTMI could be a consulting expert on is unknown. And regardless, even if it was, CTMI is so intricately involved in the fact development of this case that it cannot be a consulting expert, Your Honor. And I always hate to instruct judges on general areas of law because you probably know them better than I do, Your Honor. We get in our specialized environment. But the Supreme Court has indicated that someone cannot be both a consulting expert and a fact expert. And the case in question is, this is the Axelson versus the McElhaney case, Your Honor, Texas Supreme Court, 1990. And Apache Resist discovered dual capacity witnesses here. So several potential witnesses in this case maintain a dual capacity, possessing firsthand knowledge of relevant facts and serving as consulting only experts for Apache and El Paso. Then it talks about a couple of these persons, but they have firsthand knowledge here. The factual knowledge and opinions acquired by an individual who is an expert and an active participant in the events material to the lawsuit are discoverable. This information is not shielded from discovery merely by changing the designation of a person with knowledge of relevant facts to a consulting only expert. The literal text of the exemption, and that's the consulting expert exemption, resolves the issue presented in this mandamus. The consulting expert exemption protects the identity, mental impressions, and opinions of the consulting only experts, but not the facts. The rule we announce here today should not extend to consulting only experts, but anyway, that's probably more than what we need to know. What Frio CAD is attempting to discern here, Your Honor, are the facts. When and who made the decision to erroneously report the dealer heavy equipment inventory tax? Who made the decision to pay only on the first month of a lease? Did CTMI inform JW Power that's what it was doing? What is the basis of the knowledge of JW Power's only witness who purports to know relevant facts that was supplied to him through info from CTMI? How and when did CTMI inform JW Power that the dealer heavy equipment inventory filings should be made every month instead of only in the first month? Did JW Power and CTMI know that the November 2018 and December 19 affidavits were clearly erroneous? By the way, those affidavits we learned were drafted by JW Power's attorneys. Did JW Power intentionally present falsified affidavits and pleadings to this and other courts? Did JW Power and CTMI intentionally pursue settlements with yard counties to post facto create the illusion of multiple appraisals? Are all these matters are factual. They're not opinions. They either happened or they didn't happen. They're facts. Was CTMI a JW Power agent such that it be covered by the attorney-client privilege? Your Honor, we're dealing with Texas Rule of Evidence, in this case, 503. And again, I expect my computer to be, amazing, ready to go. CTMI is obviously not JW Power. Could it be a client representative? A client representative is a person who has authority to obtain professional legal services for the client or to act for the client in the legal advice rendered. And I don't know that's relevant. Could it be work for the lawyer? A lawyer's representative is one employed by the lawyer to assist in the rendition of professional services. We've already seen that JW Power's lawyers have disclaimed any control over CTMI. They don't work for us. Here are some of the contracts that have been produced in other cases. This is the contract between CTMI and JW Power. And I didn't highlight this one, Your Honor, I apologize. In the event of the appeal process continues to litigation, consultant, that's CTMI, will advise client, that's JW Power, as to the litigation options, the process and timing of such litigation, and consult with client and assist in the selection of appropriate legal counsel in the respective geographic area. Client is solely responsible for retaining legal counsel. Such
Just a moment. All right, go ahead.
Such retention being independent and separate from the client's engagement of consultant pursuant to this agreement. In other words, CTMI does not have the power to engage legal counsel for JW Power. CTMI shall perform services only as an independent contractor, and nothing herein contained shall be construed to be inconsistent with this relationship or status. Under no circumstances shall consultant be construed to be an employee, agent of the client, and shall not participate in its profit sharing and so on. In other words, CTMI is under the control of neither the attorneys nor JW Power. It has no authority to contract with attorneys, none to consult with them. When it reaches attorney stage, it's going to turn it over. This matter has also been decided by the Texas Supreme Court in National Tank versus Brotherton, 1993 Texas Supreme Court. Fairly short quote here, Your Honor. Under Rule 503A2, the qualifying employees must be those actually having the authority to hire counsel and to act on counsel's advice on behalf of the insured. In this case, there is no indication in the record that Precht was such an employee. There is positive indication in this record that CTMI was not such a person. And so, Your Honor, the fact that CTMI is the allegation that CTMI is a consulting expert is not supported by the facts. And even if it were, CTMI is so deeply embroiled in the facts of this case, it cannot possibly be shielded as a purely consulting expert. CTMI clearly is not a Rule 503 accepted client representative or attorney representative. It is an independent third-party contractor that did most of the factual development in this case that is pertinent. Now, I apologize again. One more thing. In order to assert a privilege, the burden is on the proponent of that privilege. Again, I share screen. This is, again, Texas Supreme Court, 2004, the E.I. DuPont and Miller's Company. I don't know what there is about French names in this line of cases, but they all seem to be French, and I'm terrible at pronouncing it, Your Honor. The bottom line is that the deponent is, or the proponent of a privilege is supposed to come forward with competent evidence to support its privileges. It's supported by live testimony or by affidavit, none of which have been presented to the court. The documents in question are supposed to be submitted to the court for in-camera inspection if the party raises an appropriate prima facie case for the privilege. I would submit here, Your Honor, that there has not been a prima facie case for the privilege, nor has, even if there been any offer of allowing the court to inspect the documents in camera or otherwise. Now, I say all that to get to the first objection, Your Honor. The contracts. Yes, but in Jack and Duval counties, the courts have ordered the production of the contracts. And with some exception, we believe we've got them. At least they've represented these. JW Power has represented the contract. You heard Ms. Seal say earlier that they're willing to forego their objections and produce them in Frio County. That's wonderful. They've told us they can't find some of them, but that does not make them not objectionable or not discoverable from CTMI. Frankly, at this point, we're skeptical of the thoroughness of JW Power's production, and to ask for CTMI for the same things, which I don't think is particularly burdensome. What's your contract with JW Power? Yes, maybe JW Power did it. If that, all they would have to say is, you see those documents that you got from JW Power in Jack and Duval counties? They're the same things. Or we also have
And let me ask, is there a separate contract for every county or for groups of counties, or is this a statewide contract?
It appears to be a statewide contract, John.
Right, Ms. Hart?
That's correct.
Go ahead.
And so that's my again, I apologize. I promise my future responses won't be a tenth that long, but that's my specific response to the request for the contracts.
All right, anything else on number one?
Well, we know that we don't have all the years, Your Honor. I mean, and that may be an honest mistake. They said they can't find some of the years, but well, okay, let's see if CTMI has them.
Okay, I mean, just on item number one on the objections and responses.
No, not on item number one. That's it, Your Honor.
All right, Ms. Hart?
Again, our position is they've gotten them. They've already gotten them. Therefore, the request is duplicative and they are more easily obtainable from plaintiff. So we should be protected from that one.
Okay, number two.
I grouped request number 2 and number 4 together because they both concern communications between my client and the plaintiff. And again, the situation is the same. Plaintiffs are prepared to, and I don't mean to speak for Ms. Seal, so if she needs to chime in, she can, but my understanding is that subject to this confidentiality order being entered, they are going to produce what I believe are the same communications that they produced in the sister cases, making them again duplicative in requiring my client to go back and search for the same communications that plaintiff is going to have. If they're communications between my client and the plaintiff, plaintiff has them. Plaintiff is a party to this suit, so they're more easily obtainable from plaintiff, and plaintiff has agreed they'll produce them once the confidentiality order is entered.
Your Honor, that is correct as to the our agreement to produce the both the engagement agreements and the communications. I do just want to point out, though, for the court, my concern, we did send over a confidentiality agreement. I really just, I want to take this opportunity after Mr. Swinney mentioned a lot of things in that argument to address some things. I want to clarify and object to representations and reliance on evidence that is from other cases that has nothing to do with this one. There have been, there's a reliance on what's in these confidential documents, which I would remind opposing counsel, we entered confidentiality agreements on, and the language in there says any documents, discovery responses, testimony, materials, or information designated or marked confidential may be disclosed by the receiving party only to the following persons and may only be used for purposes of this litigation. So there has been no such document production yet in this case because we're waiting for entry of that confidentiality order, but any use of the documents produced in other matters where we did enter an agreement really should not be allowable at all. But as for the affidavit that is pointed to over and over by Mr. Tubbs, not only are the statements within there, not only have they not been shown patently false, as has been claimed here, they actually are based on personal knowledge that can be demonstrated. But the fact is that affidavit that he's relying on has not been filed in this case. No representations at all have been made to this court. He's citing to an affidavit that was attached in a separate matter involving Shelby County. And not only that, but an amended motion for summary judgment in that case where that affidavit had been relied on was then submitted, taking the place of that affidavit. As for the affidavit that was submitted to the appraisal review board initially before this lawsuit, that has no relevance to the current matter because this is a de novo proceeding, and there's nothing that is being impeached here based on that language. So there's really no issue, I guess, before the court on those matters because nothing has been shown to be false. There's nothing that needs to be contradicted there, and to the extent it is, I would say that I think that can be done through testimony. I think that the testimony that's already been offered by Mr. Tubbs adequately covers a lot of those things. And as for his knowledge on a lot of these items, documentation has already been produced in the form of, what declarations were filed, which have, that's how we can get what date were these declarations filed on, what did they cover, were payments made in the amounts of the tax statements. All of those things can be demonstrated by the documents produced anyway. So like I said before, we're not going to sit here and fight the admission of items that are relevant and are not privileged and are related to the underlying facts. But we need to be careful with the breadth of what is being requested here in this case.
So it's your client's position that it can not engage in full discovery or full disclosure in this case. And if Mr. Swinney's knowledge that your client's not engaging in full disclosure comes from another case where there's a protective order, that he's not allowed to use that knowledge to call you out in this case?
My position is that due to the language of the agreement, a document should not be filed in another case without first it has to relate to the litigation in question, and it also provides in there that we have to be notified in advance. There's several items that were not addressed, but either way, as to the discovery in this case, there has been no motion to compel on file as to this specific request for production, which is the second request for production. There was erroneously a motion to compel filed with regard to that, and subsequently it was discovered the defendant did not actually serve the second request for production that they had filed their motion to compel based on saying we did not answer. So we did answer. The only type of conference that I have ever received with regard to the if there is any insufficiency of our own discovery responses, which I'll remind the court are not even before the court today, is a letter that was received November 6th before plaintiff's discovery responses were due, and the letter just simply states, in fact I have it here, anticipating unsatisfactory responses, please plan on a motion to compel those responses and a hearing simultaneously with the motion to compel responses to the second request. No discussion as to individual requests, but all that to say there has been no follow-up or attempt to confer on any issues with these specific discovery requests in this case. But regardless, after reading the response filed by defendant yesterday, it came to my attention they're asserting that we are refusing to produce these documents and are clearly probably going to take the same type of steps again in incurring a lot of cost and time and resources in fighting on these documents that they already have. So in the interest of not wasting that time, I have conferred and said that we are willing to produce what has been produced there. We just want to make sure there's an agreement as we've entered in the other cases and that it's followed. Did that answer your Honor's question? I don't know if that was a roundabout, if I got there or not.
Yes, Mr. Swinney?
There's a lot of things to respond to there, Your Honor. First of all, with regard to the confidentiality orders in other cases, they specifically allow the utilization by other defendants in similar matters. And we did file the confidential matters under seal as required by those confidentiality orders. Second of all, I can't cease to know things when I cross a county line. We know JW Power and its CTMI employees or tax consultants have submitted erroneous information. I think downright misleading and false information. Yes, we sent the second RFP, which hasn't the second RFP is what's an issue here to JW Power. It's not like, again, not before the court, but it will be at some point, I assume. But it asked for many of the same things that we're asking for CTMI. It took 2 motions to compel in Jack and Duval counties to get them. And even now, we're not at all sure we have everything. We could virtually know we don't have everything because there is not a peep of information in there about CTMI's filing for 4 years involved in this case. All they protest at the ARB. Either CTMI never informed JW Power what it was doing on its behalf, and JW Power never inquired about it, or JW Power didn't give us that communication. What took the CTMI is also raising the objection, which was raised by JW Power to these communications. Well, past 2017 is not relevant. It took the second motion to compel in Jack and in Duval counties to get the post 17. It was after 2017 that every action pertinent to this suit was taken. It was after 2017 that CTMI discovered, changed its method about changing, filing statements every month. It was after 2017 that all the affidavits in question were signed. It was 2019, 2020 that the motions to for summary judgment were signed. It was 2019 that settlements with yard counties were made, which we'll get into. Is frankly not relevant in this case, actually. But that's when all the relevant communications took place. There is no information in there, not a single in the Jack and Duval discovery responses, not any communication between CTMI and the lawyers, which again, they're raising the attorney-client privilege and the consulting expert privilege, which I addressed earlier. And so, no, this request is not duplicative of what we've already gotten. Yes, we'll go after JW Power for everything and keep bringing motions to compel as needed, but that does not make it not discoverable from CTMI. And in the event that CTMI did some of these key actions and did not inform JW Power, then only direct discovery against CTMI will reveal those matters.
All right. Ms. Hart, anything else on 2 and 4?
No, Your Honor.
On number 3?
Number 3, those are communications internal to my client regarding the subject property. Again, I'm invoking JW Power's consulting expert privilege, and that's from 2013 to 2020, such that it's not discoverable.
All right, and from
I have nothing.
JW Power? Okay.
Your Honor, I think I've already adequately addressed that. I mean, these matters are so intricately involved in the factual development of this case that CTMI cannot possibly be a consulting only expert.
All right, part 5.
Number 5 is documents related to the physical location of the subject property. It is my understanding that plaintiff has already stipulated that the property was physically located in Frio County, and that defendant has agreed that that is sufficient for purposes of this inquiry. So also defendant did not address this in this response. So I just don't see that my client should have to produce documents for a matter that's not even in dispute.
All right, Mr. Sweeney.
Again, if we get that information from JW Power, great. That does not mean it is not discoverable from CTMI. It is clearly pertinent to these issues. And therefore, again, we frankly have a lack of confidence in JW Power's response and are seeking the same matters from CTMI invoke.
And I don't know why there would be any.
How big are these compressors? Is this something that's on a flatbed trailer, but you can just hook up, move it? Or is this something that you've got to hire companies to go ahead with flags and measure that it's not too tall for the bridges and stuff like that, and it's a major pain to move it?
They're major pains to move, Your Honor. Now, I can show you some pictures if you want. It'll take me about 15 clicks of the mouse to get there, but they have a good deal of variety in size. The smallest of them, would probably be maybe 20 feet long and about 12 feet high. The biggest of them would be more like, 30 feet long and 30 feet high, but not 30 feet. But they have a good deal of variety in size, Your Honor.
And what are they used for? For gas plants or for fracking or?
They are used to create negative pressure on the gas wellhead and positive pressure on the distribution lines, or the gathering lines, actually.
Let me ask it again. Are they involved in the drilling process then? Or just
No, sir, they're not. They are in the production process. Like I say, once the gas well is completed, I think there's some, like distillate use as well, but they're primarily for gas purposes. The compressor is hooked up and the appropriate horsepower is utilized to create, some gas wells pressure themselves. Some you have to drag the gas out of the ground. And that big old compressor, like I say, it's creating the negative pressure on the wellhead to draw the gas out. It's creating the positive pressure on the gathering line to push it down the line.
And Your Honor, if I may,
yes.
I think what a lot of this gets into, and I can't off the top of my head, define for Your Honor the specific elements of all of this right now, but a lot of this I think gets to the classification of the property, the form of the property, and that's not something we're disputing here today, but that is kind of the crux of the dispute. Our position is that it's dealers heavy equipment inventory, as opposed to just normal business personal property. So that in itself is kind of the crux of the issues on what our claims relate to, and the reason why we are seeking the removal of the compressors from the appraisal rolls here, because essentially, without getting into all of the weeds, the dealer's heavy equipment inventory is only taxable. The taxable site is where the inventory is assigned, not where it is physically located. So the physical location actually has no relevance, but just to confirm what Ms. Hart mentioned before, we have stipulated to the physical location of the compressors, and we have in fact provided all documentation that we have related to the description of the compressors, their unit number, their serial number, their size, their weight, anything that we have on them in their location, and again, where any documents were filed or taxes paid. We have produced all of that over that we have, just to be clear.
All right. Ms. Hart, anything else on number 5?
No, Your Honor.
Number 6?
If I could group 6 and 7 together, because they are documents filed with the appraisal district. And as Ms. Steele stated, again, defendant has already requested this of plaintiff. They've already produced everything, thereby rendering it, again, duplicative and requiring my client to go back, a non-party to this case, and search for these documents when they already have everything from the plaintiff.
Mr. Sweeney?
Again, Your Honor, the fact that they're discoverable, the fact that some of them may have been produced by the plaintiff does not make them non-discoverable from CTMI. CTMI is the author of these documents, not JW Power. No, we didn't get everything. We got the most of it. And maybe it was an honest mistake. Maybe the ones we didn't get don't exist. I don't know.
Not in our possession. I'll be clear, we produced everything in our possession that's in response to the request.
Did CTMI give everything to JW Power in order for JW Power to give it to us? I don't know. But these things are matters of they're CTMI's documents. They're discoverable from CTMI.
Okay, number 8.
Number 8 requests renditions prepared, whether they were filed or not. And we actually answered that there are no such documents, because anything that quote renditions would have been filed. So we don't have anything that has not already been produced by plaintiff in response to 6 or 7.
Response? If they don't have anything, just tell us we don't have anything. Don't object to it. Frankly, I have to say, Your Honor, that we think the renditions are of marginal relevance in this case. They might reveal location. They probably would reveal location. The reason we're asking for it is because JW Power is claiming they're relevant. They're claiming that we didn't file any renditions in this case, therefore a legal conclusion. We disagree with that thought process, but let's have it. Was there any rendition filed? At Mr. Tubbs' deposition, he said CTMI would have done that. Okay, let's have it from CTMI. Did you prepare any renditions in this case? And if the answer is no, the answer is no. But that doesn't mean it's not objection, that it is objectionable.
Number 9.
Number 9, documents indicating payment of heavy equipment. My understanding is, again, that plaintiff has produced these items to defendant. Again, it's duplicative. And my position is my client shouldn't have to go back and look for these items when defendant has them and can get them from a party to the suit.
Same response as in the declarations and statements, Your Honor. We didn't get everything, maybe because it didn't exist. We don't know. But the fact that JW Power produced, granted, what is the great part of the responsive documents, does not make them non-discoverable from CTMI. At the deposition, again, JW Power says, CTMI did all this. I got this from CTMI. I don't really remember when, but sometime CTMI gave it to me. Are there some other documents out there? There can't be many other. I'll give them that. There can't be many other because we have the vast majority of them. But again, if there are, they're discoverable from CTMI. If in fact the documents we already have been produced by JW Power are all the documents that are responsive, all they have to do is say, see those documents JW Power gave you, that's all we have. But it does not mean the request is objectionable.
All right. And my understanding from the 30 seconds research I did before we started this is that under 2525, in order to affirmatively take advantage of the plea that, wait a minute, this property was, personal property was taxed somewhere else, you have to show not just that it was taxed somewhere else, but that the taxes were timely paid?
No.
No, okay.
What the situation is, there's a timely payment requirement in, it gets a little complicated, but it's not relevant in this particular case, except as to the point that JW Power has alleged they timely paid when in fact they did not pay at all. What has to be shown is the same property was actually on the roll in another county. In this case, it'd be Jim Wells County. We're getting into the merits of the pleading, Your Honor, but when we get there, we will demonstrate that with extremely rare exception, at least from the documents we have so far, the Frio-based compressors were in fact not on the Jim Wells roll. What JW Power will contend is that because we reported some compressors sometime to Jim Wells County, that means we reported our entire inventory and that therefore everything was multiply appraised. Again, we're getting into the merits and I'll be prepared to argue that another time. But right now we're exploring the truth or fiction of the claim that, and I think we have enough evidence so it is fiction, the claim that these compressors were reported to Jim Wells County, put on the roll and taxed there.
Your Honor, if I may on that.
Yes.
I think there's no dispute that there was timely payment on the dealer's heavy equipment inventory that is considered a single unit. Again, like you said, I don't want to get into all of the merits of the argument. It is very complicated, but dealer's heavy equipment inventory under the law is to be valued as a single unit. So even though there would have been some compressors that were initially if the declarations initially underreported, so some of them were left off due to a misunderstanding of how to report at the time. That does not change the fact that as a whole and as a unit, dealers heavy equipment inventory was declared and taxes were paid on that by the tax date. And so there is no, it's really not even a dispute here. I just wanted to clean that up for your honor, but it's the monthly item that he's mentioning. Again, I don't want to get into the weeds, but that's about the monthly reporting requirements. And there was initially a misunderstanding about how that should be reported, but I want to remind your honor that it really doesn't at all affect the claims at issue in this suit, which are simply whether the property was multiply appraised. And as we will get into on another day, our position is for there to be an appraisal in another county, there has to be a declaration filed with that county. That did happen here. Or whether the property was did not exist in the form or at the location described, and our position is that it did not exist in the form described, that being business personal property, because it was in fact dealers heavy equipment inventory. Again, I don't want to get into all that, but the point is a lot of the items that are being sought here today, and as it's being discussed, are taking away from what's actually relevant to the claims at issue and what actually has to be proven or disproven in this case.
And needless to say, we disagree with virtually everything that was just said. But again, we're getting into the weeds of the merits here, which I'll be glad to do if you want an explanation.
No. All right, number 10.
Number 10, request documents related to the separation of an employee of CTMI. Defendant deposed Mr. Luna, I want to say a week or two ago, and actually asked him why he left CTMI. It's his defendant attached his deposition as an exhibit, and he said he simply did not want to work in property tax anymore. It had nothing to do with the JW Power matter. He just did not like the deadlines of working in property tax. So I think this actually is irrelevant to the matter at hand, which is the taxation, the multiple taxation of property, and has absolutely nothing to do with this employee leaving, who has already stated he just didn't want to work in property tax anymore.
The response to that, Your Honor, is Mr. Luna was the signer of one of the affidavits in Shelby County. He was identified as the key person of a contact with JW Power. He was repeatedly relied on by JW Power in their communications and in the representations. He provided all the evidence that has been produced in this case. When we attempted to depose him early on, just before the pandemic or in the early part of the pandemic, CTMI refused to produce him. When things started loosening up and we tried again, he's not with the company anymore. Why is that? That at least raises some suspicions on that. And yes, Mr. Luna said it just wasn't fun anymore. Well, I took a little bit of a personal offense. I've worked in property tax, 30 plus years. I thought it was a barrel of monkeys, but be that as it may, I think we'd like to have CTMI's side of that story.
Anything else from anyone?
No, Your Honor. Thank you.
Your Honor, our response was filed on Monday early on. If the court did not receive it timely, we apologize. Something may have gone astray there.
I have not logged into the district clerk's record files to look for anything. I was just emailed the subpoena and the motion this morning by certainly someone forwarded them to the coordinator's office. All right, I will sustain the objection to number 5. I will sustain the objections to 6 and 7 as to Frio County. By that, I mean, the Frio County Appraisal District ought to know what was submitted to it, and they already have copies of that. Otherwise, I will deny the motion for protective order.
Shall I submit an order to that effect, Your Honor?
If someone would, I would appreciate it.
We appreciate it, Your Honor. One thing both sides failed to mention is CTMI's deposition is scheduled for Monday of this week. And there was one other hearing prior to it, but bottom line, this is the only county that will have a hearing prior to that deposition. So we appreciate being able to do that, and we'll get an order to you promptly, Your Honor.
All right, I will be on here for some time. I don't know how long that is until I know what happened in the family law cases. But if Zoom court is still going, feel free to just log back on and post that in chat.
Thank you very much, Your Honor.
All right, with that, you're excused.
Thank you, Your Honor.
Okay. In the interest of the Zamzo children,
Judge Porter Corrigan's present. I see Miss Vickers. There she is.
yes.
And Katie and Grady Roberts. I see them logged in. Hopefully they'll turn their monitor on. But we've reached an agreement. I've signed a Rule 11 agreement and a proposed order concerning some counseling that I've emailed to Miss Vickers.
Yes, Your Honor. It's just been emailed to my client. I don't have her signatures yet. We were looking at some court dates. I think Lori responded. Let's see. It looks like for Porter, our April dates are 12, 13, 14, 15. And then our June dates are June 7 through 10 and 14 through 17.
I have no idea.
Right. It's on the chat, Your Honor. I can talk to Porter about that without being on Zoom if you want. I can just text that to him and we can fill those in when we get it. But I expect us to have a signed order to submit and a Rule 11 to submit shortly for the order, which is ordering the people to go to a program for reunification. It would need your signature. Do you want me to send that to you through e-file, or how would you like to get that?
You can e-file it if it looks like, I don't know what's going on in Mr. Cedilos's case. If I'm still in the Zoom port, then you can just post it in chat if you'd like. Better e-file.
Okay. All right. Well, let me see when we get there. I'll do one of those two things.
Okay.
And then, so we'll report back. Let me try to get these dates with Mr. Corrigan and get those agreed to so we can fill in those blanks.
All right. Excellent.
Thank you, Your Honor.
Thank you, Judge.
Do y'all need another breakout room?
That's probably not necessary. I think I can communicate with Ms. Vickers via cell phone.
Yeah,
Okay.
we'll just text each other, Lori. Don't worry about a breakout room.
Okay.
Thanks.
You're welcome.
Thank you, Your Honor.
Okay.
May we be excused?
Yes, sir. You're all excused.
Thank you.
All right. Mr. Cedilos, what's going on in your case?
I think we're making some
Sorry,
slow
we
progress.
did not reach an agreement.
All right. I'm sorry, Mr. Cedilos. Go ahead. I was muting Mr. Roberts.
Okay, we could not reach an agreement, Your Honor, so we'll need a hearing. We'll need an hour. It's temporary orders.
Okay, we're going to take a brief recess. We'll come back at 10:30 and we will start that hearing.
All right, thank you, Your Honor.
All right, calling in the interest of EMC a child, are both sides ready?
Yes, Your Honor.
Yes, sir.
All right, do you want to have your client start his Castaneda?
Yes, sir.
All right, let me ask the parents to both raise their right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and your name for the record, please, sir?
Abunjo Castaneda Jr.
All right, and you may put your hand down and your name for the record, please, ma'am.
Ariel Cordaway.
All right, and let me ask, is the Karnes District Clerk, are y'all available? Hello?
You want me to call over there, Judge, or?
That's okay, just before they get off, Richard Briggs had emailed me 2 vouchers, and I signed them and posted them in chat, but I wanted to make sure they knew that, because
Okay.
they didn't necessarily have any reason to think that I would be sending them something. All right, go ahead,
Okay.
Mr. Cedios.
Okay, Your Honor, I'm going to call my client, Abundo Castaneda.
Okay, let me know first what this case is about.
Okay. Your Honor, there are no orders in place. Mr. Castaneda and Ms. Cardaway were living together up until about December of 2020.
Will you call Karnes County and tell them that Judge Wilson posted 2 attorney vouchers in the chat they need to pull up?
I'm sorry, go ahead, sir.
No problem. Yeah, they were living together up until December of 2020. The child is approximately 1.5 years old. When Mr. Castaneda left, I mean, he was told to leave, so and we'll show, there was evidence that he was allowed to take the child at that time. There's been some visitation, but with hesitation on my client's part because of concerns with drugs. So today we're asking for temporary orders and allowing my client to be the primary conservator.
All right, ma'am, and let me ask you just for a brief overview of what your case is. This is not an opportunity for you to testify. It's just, you'll get that shortly. So do you have a brief overview of what your side of the case is?
I was just wanting my daughter to stay with me.
Okay, all right, go ahead, Mr. Cedios.
Okay, Abundo Castaneda, would you state your name?
Abunjo Castaneda Jr.
Okay, and you known as AJ, right?
Yes, sir.
Okay, and this suit is regarding your daughter, Elena?
Yes, sir.
Okay, and you're on the birth certificate?
Yes, sir.
Okay, and there are no orders in place, right?
Yes, sir.
Okay, when was Elena born?
She was born February 5th, 2019.
Okay, and did you and Ms. Cardaway live together up until December of 2020?
Yes.
Okay, and you shared responsibility in trying to raise her?
What was the question?
You shared responsibility in raising her?
Yes, sir.
Okay, what day did you leave in December?
I left in December 10th, 2020.
Why?
There was a lot of violence already going back and forth, more conflict with yelling at each other. And I was pretty much already with stress to like taking care of not just my daughter, but also the other 4 kids that live in the house while the mother was out drinking and having her fun.
Okay, now you said, do you have any children of your own?
Yes, I have another daughter and she lives with her mother.
Okay, So what happened on December 10th? Tell the court everything, because the court hasn't heard anything other than what discussed today. Just
December
briefly.
10th, December 10th was right before the weekend, or one of the weekends that I was already getting fed up with her going out till 6:30 in the morning. And I tried talking to her about it, but it always leads to a conflict and fighting. So I decided to leave the household. The following Monday that came up, I had taken possession of my daughter. She was given to me by her mother on the December 14th, when I was letting her know that I was turning off utility off in my name.
Okay. And you gave her notice that you're turning off the utilities, right?
I got there and I told her that she needed to go to City Hall and put it under her name. And she got upset, saying that she didn't know she was gonna be able to take care of Elena or have the power on. So she did that in front of a Cuero PD officer and handed me my daughter.
And do you know the name of the Cuero Police Department officer?
No, sir.
Okay. But he voluntarily, or he didn't try to prevent you from taking her?
No, sir. He was just more telling me that he would involve CPS if I turn off the electricity on Miss Cordaway.
Okay. Was Miss Cordaway resistant to you taking the child that day?
No, sir. She gave her to me and let me pack some clothes for her.
Okay. Was Elena walking at that time in December of 2020?
No, sir.
And how old was she at that time?
She was in 2020. She was a year and 10 months.
Okay. Now, was Elena and Ms. Cordaway and you getting any kind of help, assistance from a government agency?
Yes, sir.
What kind of help?
The help was from ECI, and it's a early childhood in it's early in childhood. Can't remember the last part of the name.
Um,
All right, Ms. Cordaway, if you have a legal objection to questions or the answers, you may certainly make those, but this is not a time for you to testify. You will be allowed both to ask questions of this witness later and to testify on your own behalf later, okay?
yes, sir.
Go ahead, sir.
And they were helping, and they were going to the house to help Elena with walking. It was a physical therapist for her.
Okay. And since December 14th of 2020, Elena's been with you, is that correct?
Yes, sir.
And have you seen ECI or people with ECI at your house or wherever you need to take her?
Yes, sir. I do the video chat on Zoom, like way we are doing. And then I also have her physical therapist that comes to the house, and I see them at least 5 times out of the month.
Okay. As of today, is Elena walking?
Yes, sir. She is walking and she is starting to run, walking backwards. She is moving forward with her process.
Okay. Was the help that you were doing with ECI more consistent than with Ms. Cordaway, as far as your daughter's concerned?
I would say yes.
What would happen with Ms. Cordaway's appointments in ECI?
She was canceling. Don't know why. If I can do it, I'm doing it right now, where I see them video chats. Even when I'm sick, we still do live video chats so they can see my daughter and see how much she's moving forward. I don't know what her reasons are.
Okay, where do you live right now?
I live in Runge.
Okay, and who do you live with?
I live with my dad.
Okay, and would you describe the house for your dad, for the judge?
It's a three bedroom, 2 bath house. It has
Okay.
a fenced in backyard and well maintained. She has the food, water, electricity, running water. And there's 2 reliable vehicles here.
Okay, do you have, and you have visitation with another child, right?
Yes, sir. That's
And
my oldest daughter.
how old is she?
She will be 7 this month.
Okay, does she get along with her, with Elena?
Yes, sir. Yes, sir.
Okay, and you see her consistently every other weekend when you're required to see her?
Yes, sir. I see her the first, the third, and the fifth week of the month.
Okay. Are you currently working, AJ?
No, sir.
Okay. What are your plans as far as work or education?
Next week on Monday, I take an online course for the security, a level 3 security license, so I can be able to move forward on trying to drive armor trucks.
Okay. Now, when you start that process, does Elena have a way, or do you have a way for Elena to be supervised, to be watched?
Yes, sir. I got 2 sisters that'll be in the area, and then I got 2 babysitters, and then I'll looking just in case for the daycare enrollment, which ECI says they will help me with that process with the daycare for Elena.
Okay. Now, the last time we were here, we were in front of Judge Ellison, and by the time we got to our case, after a long case, it was about 2:30, and I represented to the judge that I had to go get my booster shot for my COVID. So what did the judge tell you? What did the judge tell you regarding visitation with Ms. Cordaway and her daughter?
That Miss Cordaway said that she hadn't seen her daughter in a month or 2 months.
Okay, and that was on March the 4th?
Yes, sir.
And she had seen her daughter, is that correct?
She's seen her daughter in the ending of January.
Okay. And what was the problem with the last visitation that you allowed Ms. Cordaway to see her?
Me and Miss Cordaway was already getting in a conflict, and when she wanted to take Elena, she asked for a couple of things, and I gave her what she wanted, and I let her take her daughter after the visit. She visited with her daughter here for a little bit. Then I let her decide to take her daughter. As soon as I was strapping her car seat into Miss Cordaway's gray 4-door Expedition, I smelled marijuana in it, and I told her it stinks in her vehicle. And when she finished, she got in there and strapped the rest of the car seat down, telling me, "What am I talking about? That smells good." It was her friend, Alfonso Hernandez, that was smoking in there, which she calls him Pudge.
Okay, so you didn't, did you allow future visitations in February based on what happened, or the smell, the odor?
I told her she was allowed to, I told her she was more than welcome to see her daughter. The only thing was she was not taking her daughter.
Okay, do you want to take a hair follicle exam?
I'll take one.
And you want Ms. Cordaway to take a hair follicle exam?
Yes, sir.
Okay, would you describe for the court how the situation was at her house? I mean, tell me, how many kids does she have?
She has, Elena makes 5 kids. She has a total of 5 kids.
Okay, would you describe the party or the situation there at the house?
At first, there used to be a lot of people going over and drinking and other drugs. When I was first with Miss Cordaway, I never used to be involved with that kind of drugs, anything like that. And when I got laid off to COVID, trying to find work, couldn't find work because nobody was hiring. Just fell into, I was always around the same people all the time. So I fell into that bad group with Miss Cordaway. Has always been around the same group of people for years. And she did drugs, and I fell into her lifestyle of doing it too with her. I left that style. I left that house because I didn't like who I was becoming in that house. And I did not want my daughter to become anything like that. Her brothers do the drugs. Her best friends do the drugs.
Is it being
And
done?
I just don't want my daughter to be like that. And yes, the house was getting to the point where Section 8 house was not even, it didn't even feel like it was a house for kids anymore. It felt like it was just a place where people, her friends, were going there to drink. And after a while, I told her I didn't want it there. So she started staying out till 6 in the morning, and she was doing it with her friends somewhere else, not there at the house anymore.
Okay. So that's basically why you took your daughter.
I didn't take her. She handed her to me both times, even after the time I told her I wanted to see my daughter again. She also handed her wheeling to me and put the car seat in my truck. I never took my daughter. She was handed to me.
Okay. But today, what are you asking the court for?
I'm asking to have my daughter in my possession, for her to live with me so I can still help her grow with ECI, and Ms. Cordaway to have her rights to visit her daughter while paying her child support for Elena.
Okay. Since the March 4th hearing in front of Judge Ellison, she's had a couple of visitations, is that correct?
Yes, sir.
Okay, weekend visitation?
Yes, sir.
Okay. This Sunday, what was unusual about when Elena was returned to you?
Sunday was where Elena came back with a scratch on her or mark on her neck. And she had, I don't know if it looked like a bruise or a bite mark, but her whole back of her ear in this area was all red. And the swelling barely went down today, was barely going down.
Okay. Judge,
When I picked her up Sunday too, when I picked her up Sunday, she looked like she'd been crying all day. Her eyes were red and her face just looked like she was so sad.
Judge, I'm gonna attempt to put some photos up or put a couple of photos up.
Go ahead.
It says something about says the file is blocked for security reasons.
Okay, is it a PDF?
Yes.
I don't know, it says that sometimes. Sorry.
Okay. AJ, when you took your daughter to Ms. Cordaway on Friday, when y'all are meeting in at a convenience store, right?
Yes, sir. We were meeting in Yorktown at the Texans. When I dropped her off Friday, Elena didn't really want to go with her mother. And when she did go with her mother, she was crying and screaming.
Okay. Did she have any kind of marks like that?
No, sir.
Okay. So those are new marks that came out during the weekend.
Yes, sir.
Okay. AJ, do you want child support?
For Elena, yes. But other than that, I don't care for it. If there was a way we can put her child support in a bank where she can touch it when she hits 18, I'm fine with that. I don't need Ms. Cordaway's money to take care of my daughter, but I would like for her daughter to have something for her.
Okay. AJ, do you feel Ms. Cordaway has 4 other children? Do you feel she can give her enough time to
No,
help raise
sir.
her?
No, sir.
Okay. When Ms. Cordaway was pregnant, what did she want to do with this child?
When she found out she was pregnant, she wanted to have an abortion.
Okay.
And then when she found out she was having a girl, she didn't even want her.
Okay. How many girls does she have now?
She has three girls and 1 boy.
Okay. I'll pass the witness, Your Honor.
Ms. Cordaway, this is an opportunity for you to ask questions from this witness. Again, you'll have an opportunity to testify shortly, so it's not for you to testify, but for you to put questions to the witness. What questions do you have for this witness?
I really don't have any questions, but I do have some of the stuff Mr. AJ was saying is not true, but
Okay, and you'll have an opportunity to testify on your own
Right.
behalf shortly.
yes,
All
sir.
right, Mr. Cedillos,
I'll call Ms. Cordaway, Your Honor.
go ahead.
Ms. Cordaway, are you working right now?
Yes, sir.
Where do you work?
Ancient Care. It's a home health provider service.
Okay, and how much do you make?
It just depends on how many hours. I'm not sure how much I make. I never really got that far. I never really asked, to be honest.
Okay. What's the address for Ancient Care?
Yes, sir. I don't
What's
have
the-
I don't have the address with me right now, but it's in Victoria, Texas.
Okay. How many children do you have?
I have 5 kids.
That includes Elena, right?
Yes, sir.
Okay, is it fair to, would you agree with me that you did want to abort Elena?
No, sir.
You never wanted to abort her?
No, sir.
Okay. Who lives with you in the house? In your
Me
house?
and my 4 kids as of right now.
Okay. Do you have any boyfriends living there?
No, sir.
Okay. Are you willing to submit to drug testing?
Yes, sir.
Okay, hair follicle exam?
Yes, sir.
Okay. When you gave the Elena to AJ in December, was a policeman there?
Yes, sir.
And she was not taken, was she? I mean, she wasn't kidnapped?
No, sir.
Okay. All right, that's all the questions I have, Your Honor.
Okay, do you have any other witnesses?
No, Your Honor, I do not. No.
All right, and Mr. Cedillos, so what are you asking for a hair follicle test for other than your client testified he smelled marijuana in Ms. Cordaway's vehicle?
Well, we'd like a 10-panel test and each party pay for it themselves, Your Honor. 10-panel hair follicle exam.
All right. Do I have any testimony that there's been abuse of anything other than marijuana?
I can ask AJ. Can I ask him, Your Honor?
Yes.
Mr.
Yes, sir.
Castaneda, was there any other use of any other drugs?
Yes, sir. There was use of cocaine. There was use of the mushrooms, ecstasy.
Okay. In fact, was someone intoxicated and killed in an automobile accident coming from Ms. Cordaway's home?
Ms. Cordaway was having a party and one of her friends was at the attending party and apparently they had an accident in Victoria that next day, that early morning.
Okay. All right, that's all I have, Your Honor.
All right, ma'am, do you have any questions for the witness at this time?
No, sir.
Okay, what do you want me to know? What testimony do you have?
Okay. As far as Elena, whenever I dropped her off, she was crying because I turned off her cartoons and I just got done changing her pamper because she had pooped. That's why she was crying. She wasn't upset because she didn't want to be with me or anything like that. She did have a little bit trouble coming to me when he did drop her off, but as soon as she got with me, she was happy, laughing, playing. As soon as she got home, walking around, giving me hugs and kisses, all this other stuff. Her siblings were here as well. She was playing with, you know how kids are, they play and fight, and she had fell. I'm not sure where she got that mark behind her ear that he's talking about. But I knew she has some like dry skin back there that I had washed off when I had took her a bath. As far as my friend, the one he just talked about, she was not leaving my house. I had no idea where she was coming from that night. I had not spoken to her with a couple of weeks before that accident happened. As far as the partying and stuff at my house, my kids were not present when that happened. If I ever did have friends come over and stuff like that, it would be on the weekends. My kids were not present. They would be at their father's on the weekends. And or AJ would also be here as well. But that wasn't true about all that stuff like that. And we did fight a lot and all that stuff, but I wouldn't say we just grew apart of our relationship as far as him taking my daughter. I did hand her to him, didn't fight about it because he did threaten to get my utilities shut off and all that, which I had got cut on that same day, but I told him if he could bring her back. And he told me, he called, text, I had a bunch of messages of him threatening me as well, saying
What
he's
do you mean
gonna
by threatening, ma'am?
like he's gonna do anything he can to ruin my life, get all my kids taken from me. He threatened CPS on me, which he did. He did call them on me. I did hair follicle and urine test for them as well. He always constantly texts.
And when was that?
So it was in January. I'm not sure exactly
Of
what
this
day
year?
it was, but if I could get in contact with the lady who, I think her name was Janelle with CPS Services, I could get in contact with her and get those results for you if you need me to. I
Okay,
still,
you can represent, if that's what you're doing, that they came back negative. Is that what your testimony is, or?
yes, sir. And then he's always saying like he's never gonna let me see my daughter again. If I don't want to be with them, then he's gonna do anything he can to basically make my life miserable and stuff, you know, stuff like that, and using my daughter against me to, you know, make himself feel good, I guess is what you want to call it. I'm not sure. I just want my daughter to live with me, and I think she did, you know, she needs to be with her mother. I also have my 4 other kids living with me as well, her sisters and her brother, and I never had any problems with CPS with them, or I never had got my kids taken away from me. I've taken care of them, worked, I've done all that stuff to provide for my children. But that's all I have to really say.
Right, Mr. Cedillos, anything else for this witness?
Would you submit those hair follicle exams to me and the judge?
Yes, sir, I wouldn't mind it.
Okay.
But I have done it already through CPS, though, is what I'm trying to say. You know, like
Ma'am, I think what Mr. Cedillos's question is that if you have one as recent as January, I think that would satisfy,
you know,
as long as you can get copies of it, that would satisfy any request for,
yes, sir. Actually, it was in February. I'm sorry, sir.
well, that's even more recent.
Yes, sir.
Okay. And I just have a few questions for my client, Your Honor.
Go ahead.
AJ, you heard Ms. Cardaway's testimony about you threatening her. Did you ever threaten her?
No, I just told her I didn't see it as a threat if you're not going to see your child. And she did not try to see her child. She called me to tell me that she was having a party at her house. So that was a lie. She did see her friend, the one that died. She was drinking with her recently because she had told me she was having a party there with those people there. So I don't know what she's telling you about that. Yes, you know, when you get mad a little bit, I did use that. I did say, oh, you're not going to see your child. But I've still told her she was more than welcome to come see her child.
Okay, but did you ever threaten any violence against her?
No, sir. I've never put no kind of violence really at her. Now on the other hand, when I tried leaving, she hit me in the face. She's put her hands on me.
Okay. All right, I'll pass the witness, Your Honor.
Ms. Cordaway, do you have any other questions for this, Mr. Castaneda?
No, sir, I don't have any questions.
All right, anything else from either side?
No, Your Honor.
All right. Brief argument.
Judge, Ms. AJ, I think the biggest point that is not disputed is that AJ dedicated more time to getting Elena with the early childhood ECI, early childhood intervention. She's walking now. In December of 2020, she wasn't walking, and she's now walking. AJ, Mr. Castaneda, does have more time to devote to his daughter. There's only one child and then visitation with his other child. AJ feels he can provide a better environment for his daughter. And we're asking the court to make him primary, just allow visitation with Ms. Cordaway, and child support, minimum wage child support based on, she's got 4 other children in the house. That's what we're asking for, Your Honor. That's what AJ is asking for.
And Ms. Cordaway, what are you asking for?
I'm asking for my daughter to be living with me and AJ be put on child support.
Okay. All right. I want to remind everyone that this is just temporary orders. Meaning that it's just orders that are in place temporarily until this matter is finally resolved. I will appoint the parents joint managing conservators of the child. I will allow at the present time Mr. Castaneda to establish the residence of the child in Karnes County. I will include a loving and caring order and a no disparagement order. In the no disparagement order, she's a bit young, but she's, I guess, past 2 now, means that neither you nor your relatives or anybody else that is connected with you can badmouth the other parent, the other parent's family, friends, house, or anything else. Whatever disputes the 2 of you have are your disputes, and your daughter is not part of that. And it's very improper and harmful to your child to try and drag your child into it. I will allow Ms. Cordaway to select either the standard visitation or an alternate visitation. And by alternate visitation, I mean, ma'am, it sounds like the father or fathers of your other children routinely exercise standard visitation, okay? If you exercise standard visitation, then you'll have Ariel all to yourself. That might be what you want. It might be that you want her to be able to see her siblings. So I'll let you select whether you want the standard visitation, so you have her all to yourself, or whether you want an alternate visitation, which would probably be might be a bit less. Well, it'd be the 2nd and 4th weekends. So it'd probably be a weekend or 2 less a year, but it would allow you to let Ariel be with her siblings, and it sounds like she was used to that. And how many hours a week are you working, ma'am?
It depends on when I get called in, sir. It's usually from 2 to 6. But I just got told earlier this morning that my hours got changed, which I haven't checked up on that just yet. Okay.
In the last month, how many hours a week have you typically worked?
It varies, sir. I would say in a month. I know it's like usually 11 hours a week, maybe a little bit, 16 hours a week. I'm not sure. I really can't say, sir.
And what childcare do you have for your other 4 children when you're at work?
They stay with my brother, Angel. He's no longer working, so they stay with him.
Okay. I will, for temporary orders, order Mr. Castaneda to provide for child support. I mean, for a visit, medical insurance, and I will order child support with one child based on 4 other children at being employed 16 hours a week at minimum wage. And that would likely, if this remains how the child is staying, go up on permanent orders, ma'am. But the economy is still opening back up, and I'm not going to order child support based on 40 hours of employment a week right now. Mr. Cedios, how long would it take you to get that worked up?
A couple of days. I can get it out by tomorrow, and I can mail it. I can mail it or email it to Ms. Cordaway so she can review it.
All right, ma'am, don't say what it is out loud because we're being broadcast on the internet, but do you have an email address?
Yes, sir.
Okay. So what I'm going to ask is that Mr. Cedios is going to draft an order that reduces this to writing. He's going to send you a copy of it, and you're not being asked if you agree that with what the order says. You're being asked if you agree that what the order says is what I have ordered. If you agree with that, if you will sign it or email back to Mr. and return it, or email back to Mr. Cedios that you don't object to the form of it, then he can submit that to me electronically, and that will be the end of it for temporary orders. And let me ask Ms. Riley, what's a good date for an entry date if they're not able to get that?
Anytime next week, except for any day next week, 22nd, 23rd, 24th, or 25th. A week away would be, the 24th, if he thinks that date.
Okay.
Okay, so I'll set this for an entry date on the 24th. And again, if it's already been signed up, no one needs to be here. And I will also order Ms. Cordaway to provide a copy of the hair follicle test that she took through CPS to Mr. Cedios within a week from today. And ma'am, do you want Mr. Castaneda to submit to a hair follicle test?
Yes, sir.
I'll order Mr. Castaneda to submit to a hair follicle test within 1 week from today at his own expense, 10 panel.
Okay. Ms. Cordaway has my number. It's on the pleading. She can call me with her email address, or I can just mail it out there today, and she'll probably get it by Friday.
Okay, you could mail it to me. That would be good.
All right. Okay, I'll do that, Your Honor.
All right, then you are excused, and let me sign the orders in Frio County for Ms. Vickers. Is the Frio County clerk still online? No. Yeah, district clerk. Is that Frio County?
Yeah,
Yes,
they're
Your Honor.
online.
Okay, give me just a moment. I'll get these signed up. And Karnes District Clerk, did you receive the two? They gone? No, there they are. Did you receive the two vouchers I assigned for Richard Briggs?
Yes, Judge, we did.
Okay, excellent. All right, then Karnes is excused, and let me get these signed.
And Judge, what was your ruling on the JW Power Company? I didn't catch that.
I denied almost all of the motion for protective order on the discovery, and they're supposed to submit an order.
Okay.
I know Christina Patton logged on recently. I don't know if she's with that case or.
I'm not sure who she is.
Your Honor, I have one more question, sir.
Yes, ma'am.
As far as my visitation with my daughter, has that changed any, or are we just, how is that working?
All right. Mr. Cedillo is going to put you need to tell him whether you want standard visitation, which you can find that online. It should be in his proposed order too, which is this first, third, and when there is a fifth Friday, fifth weekend of the month, all of those things that you, I think, are already used to. Or alternatively, you can select a visitation where it would be just the second and fourth weekends if you want your child to be with you. And if you, I don't know if your father, if your other children does the weekend, does like Wednesday or Thursday nights, things like that.
Weekend, sir?
Okay, well, you can either select it so that you have all your kids together, or you have your daughter Ariel by herself if your father's. It's whichever you want to do. That's your option.
Yes, sir.
Okay, all right. And you can always talk to hire an attorney of your own too.
Okay.
All right, I wish you good luck, ma'am.
Thank you.
Okay, I just posted those two signed orders to the Frio district clerk. Would you try and open them up and make sure they open, because about 5 or 10% of the time, probably 5% of the time, whenever these things pass through Zoom, they become corrupted and they will not open.
Yes, Your Honor, I'm checking them right now.
Is that the order from Vickers, Judge?
Yes, ma'am.
Does it have a reset date, or can you post it so I can pull it up as well? Are you able to do that?
I can give you the reset dates, Lori. if you-
Okay. Yes, okay.
We picked April 15th and June 7th.
April 15th and June 7th would be for final hearing?
Well, yeah, well, just pending matters. I don't know if it's going to be the final hearing. These people have to go through a program.
Okay.
And so I'm not sure exactly, but that's going to be the date that happens after the program is supposed to be completed.
Okay. So April 15th and June the 7th.
Yes, ma'am.
Thank you.
And thank you, Your Honor. We did receive it. We received the order and the Rule 11 agreement signed.
And they both open up?
Yes, sir.
Excellent. All right. And I will go over the document with the coordinator. Ms. Cavazos, you're excused. Christina Patton, do you have anything while we're online? No? Okay. All right. Let's see, Frio County. I have 4:15 and 7 on the Zamzo children.
Okay.
Is it Zamzo?
Zamzo, I think is how they usually
Zamzo is
say
how they
it.
pronounce it. Okay. With and the Rule 11 agreement was signed.
All right. I can call the clerk, I guess, Your Honor, and see about getting a copy.
Yes, Ms. Vickers. If you like, I can email you a copy.
Oh, that would be great. Email me a file stamp copy and I'll send it to Mr. Corrigan and Mr. Roberts and the client. We can get that going.
Yes, ma'am, I will do that.
Thank you so much.
Thank you, ma'am.
Okay. So
May
do
we
you
be
need a-
excused, Your
Yes,
Honor?
ma'am. Do you need a non-file stamp copy?
No, I'll just get a file stamped. Will be good.
Okay. All right. You're excused.
Thank you, Your Honor.
All right. The next one is reset on request in.
Okay.
Trying to type here. Sweeney to file order.
By Sweeney. Okay.
On the Kearns case, Ariel Cordaway pro se on the defense side, 324 entry.
You got that?
And on the Wilson case, Gerald and Lila Valdez are now pro se. Reset on request.
All right, good deal. Okay. And I don't know, I sent you an email on that LaSalle County special setting. Did you see that jury trial?
Yesterday or today?
I think I sent Monday. What's today? Monday or I think it was Monday.
And that was just what I taught. Judge Reyes came over and spoke to me yesterday.
Okay, good. Okay.
So I assumed that was it, and I just moved it
Yes.
to my pandemic. Okay. I'm working on the reopening orders. I want to get those done today. Hopefully not, we're finishing kind of early.
Okay, good deal. All right, Judge. You have
And
a
Your
good day.
Honor, I'm sorry, may the district clerks be excused?
Yes, we're finished. So
Okay, thank you.
Excused.
All right, Judge, you have a good day.
See you tomorrow.
Bye-bye.